Hi, this is Ira Puranik, and today I will be answering the 10 most asked questions from our community around inheritance. What happens if somebody dies without a will in India? So, if someone dies without a will, it's called dying intestate, and in that case, the inheritance happens according to a personal succession law based on the individual's religion. So, for Hindus, Sikhs, Jains, Buddhists, inheritance usually follows the Hindu Succession Act. Now, property in this case typically goes first to class 1 heirs, which include spouse, children, and mother of the deceased individual, usually in equal shares. For Muslims, inheritance follows the personal Muslim law where specific shares are predefined. For instance, the spouse, the children, and parents of the deceased individual may receive fixed proportions depending on who survives the deceased individual. Also, a Muslim cannot freely will away their property because certain heirs have protected shares under their personal law. For Christians and for Parsis, succession in India is governed by the Indian Succession Act, where the spouse and children usually inherit the property together in legally defined proportions. This is why two families who have identical assets can still have completely different inheritance outcome depending on their religion and family structure. Also, a lot of disputes happen because families assume that the eldest son, nominee, or the spouse will automatically get everything, which is legally incorrect. When I say the word property, it just does not mean your real estate or your immovable property, but also your movable property, which includes your investments, your savings in mutual funds, your fixed deposits, etc. What is the difference between an ancestral property and a self-acquired property? Now, see, self-acquired property is something that a person bought, earned, or received using their own money. An ancestral property usually means that the property was inherited through 4 generations without partition. The biggest difference here is control. So, a person usually has full freedom over self-acquired property and can leave it to anybody they want through a will. But ancestral property creates birthrights for legal heirs, including daughters after the 2005 amendment in Hindu law. The Supreme Court has repeatedly clarified in the recent years that property that is inherited from parents does not automatically become ancestral property. The source and history of this property also matter legally when it comes to deciding whether or not it's ancestral. Courts have also consistently upheld that owners have much wider freedom over self-acquired property as compared to an ancestral property. Can a will be challenged by family members in the court? Yes, absolutely. A will can be challenged by family members on grounds like fraud, coercion, suspicious circumstances, lack of mental capacity, or improper execution. For instance, if someone believes that the person signing the will was pressured, manipulated, or was very ill or not mentally fit while signing the will, they can approach the court. But the Supreme Court has also recently clarified that merely excluding legal heirs from a will does not automatically invalidate the will or make it suspicious. A person is legally allowed to distribute their self-acquired property according to their wishes, however they want. But courts may still examine such wills more carefully if the exclusion appears unnatural or unexplained, which is why proper drafting, witnesses, medical clarity, especially in old age, and documentation becomes extremely important in estate planning and will creation. Do daughters have equal right in ancestral property? Yes. Under Hindu law, daughters have equal rights as sons in ancestral property. The Supreme Court has also clarified this, that daughters are co-parceners by birth, which means that their marriage does not invalidate or remove their rights. So daughters can inherit, seek partition, and claim their share in ancestral property just like sons. A lot of families still emotionally operate on older social norms, but legally the law has changed significantly on this matter. Can parents legally disinherit their children? For self-acquired property, usually yes. Parents can leave their self-earned assets to anyone through a valid will, including one child, a spouse, a charity, or even somebody outside the family. But ancestral property is different because legal heirs already have birthrights in it. Also, simply saying that I disown my child publicly does not automatically remove the child's inheritance rights. Courts rely far more on properly drafted documents than just verbal arguments and statements. Is registering a will compulsory in India? No, a will can still be legally valid even if it's not registered, but registration gives the will a stronger presumption of genuineness and reduces the chances of dispute, tampering, or forgery allegations later on. Also, when a will is registered, the onus of proving that the will is fraud falls upon the one challenging a will. And for a valid will, basically, it should ideally be signed by the person who's making it and should be witnessed by at least two people. Also, now probate is no longer compulsory in India, but remember that banks or financial institutions may still ask for it, especially if the case is complex, has multiple legal heirs, or is a high value case. So, while registration is not mandatory, it definitely can help you circumvent legal challenges and make execution smoother. Does the nominee become the legal owner of assets after the individual's death? No. In many cases, especially bank accounts, mutual funds, shares, and insurance policies, the nominee is only the person who receives the money first. Think of them only as a trustee or a custodian. The final ownership still depends on the will or the succession law. This is one of the biggest misconceptions in India because many people think that nomination automatically overrides inheritance law. In reality, nomination only helps institutions transfer assets smoothly, but legal ownership is still decided separately. That is why nominations and will should ideally complement each other. You should have nomination across all your assets, but the final ownership of your asset will be dependent on the succession law or if you have a well-crafted will on that. What happens to an individual's loans and debt when they die? Well, loans and debts do not simply disappear after the individual's death, but if there's a co-borrower along with whom the deceased individual had taken the loan, that person remains liable to continue the repayment. Otherwise, lenders can recover dues from the deceased person's asset or estate. But legal heirs are generally not personally responsible to pay beyond the value of the assets that they inherit, unless they were, of course, guarantors or co-borrowers themselves. For secured loans like home loans, bank may also recover dues through the property sales if repayments stop. What is the safest way to divide my property amongst children without any dispute? Well, the safest method is clarity, honest conversations, and documentation. A properly written will, updated nomination, clear asset record, and open family communication, of course, reduces disputes massively. Many inheritance fights happen not because families lack assets, but because expectations were never documented properly. For a larger family with complicated assets or cross-border assets, people use family settlement trusts or even partition agreements. One major issue in India is that families avoid inheritance conversation unless it's too late. By then, emotional misunderstandings become legal disputes. The earlier these conversations happen, the smoother inheritance usually becomes. What is the difference between a settlement deed and a partition deed? So, a partition deed is used when co-owners or family members divide property amongst themselves and each person gets a defined share. For instance, three siblings jointly own an ancestral property and they decide who gets which floor, land portion, or asset. That division will be recorded through a partition deed. On the other hand, a settlement deed is different. So it is usually used when one person voluntarily transfers their property to another person, often within the family, to avoid any future dispute. For instance, a parent may transfer a house to their children through a family settlement deed during their lifetime. The biggest difference is that partition deed equals division amongst existing co-owners and settlement deed equals transfer or arrangement of ownership, usually to settle future claims or disputes. Both are very commonly registered documents and can have stamp duty implications depending on the state in which the property is registered.